Good afternoon, ladies and gentlemen. The ranking member, the gentleman from Virginia, the primary sponsor, just entered the room, and Mr. Scott, the ranking member, is on his way. But in the interest of time, I'm going to go ahead and give my opening statement and then recognize Mr. Scott when he gets here. Today, the Subcommittee on Crime, Terrorism, and Homeland Security is conducting a legislative hearing on H.R. 4777, the Internet Gambling and Prohibition Act. H.R. 4777 is very similar to legislation that the Judiciary Committee considered and approved during the 107th Congress. Currently, federal law is unclear as to whether or not Internet gambling is prohibited by Section 1084 of Title 18 of the United States Code. H.R. 4777 clarifies the law in this area by prohibiting Internet gambling and updates existing language to bar use of new technologies such as wireless access to gambling sites on the Internet, which were never envisioned when Section 1084 was originally drafted in 1961. The dramatic explosion in Internet gambling raises complex criminal and social issues. From a law enforcement perspective, this new multi-billion-dollar industry has attracted organized crime because of the ease by which criminals can launder money and increase illegal revenues without fear of prosecution or even investigation. Unlike authorized and regulated wagering in the United States, Internet gambling businesses operate in an environment free of regulatory oversight and even a remote possibility of civil or criminal enforcement. As a result, Internet gambling has turned into an industry ripe for organized crime domination. The rapid growth in this industry also raises other concerns for our communities. Millions of Americans suffer from gambling addiction, resulting in financial debt, depression, unemployment, bankruptcy, divorce, homelessness, and in some cases even suicide. While the Internet has certainly been a boon for our economy, our productivity, and our general welfare, one downside of the Internet has been the ease by which troubled adults and our children gain access to addictive gambling sites. This is a problem which must be addressed in order to protect our communities and our youth. We are fortunate today to have the original sponsor of H.R. 4777, the distinguished gentleman from Virginia, Representative Bob Goodlatte, to testify and explain the details of his bill. He's the sponsor of past Internet wagering bills and probably knows the issue as well or better than any member of Congress. Mr. Goodlatte, as you know, our subcommittee also has experience in this issue, and we look forward to your testimony. Suspend just a I just apologize to the distinguished gentleman from Virginia. I was not overlooking him, but in an effort to save time, I gave my opening statement before Mr. Scott got here, because we are going to have a vote, I suspect, within an hour, but perhaps a little longer than that. So I hope we can get to the business at hand. And at this point, I am pleased to recognize the distinguished gentleman from Virginia, the ranking member, Mr. Bobby Scott.
Thank you, Mr. Chairman. Mr. Chairman, I noticed that 1 minute past 2 that you're on the third page of your statement.
The gentleman will slip it, but look at the time we say.
It is a pleasure to be here, Mr. Chairman, and I'm pleased to join you in convening this hearing regarding federal regulation of gambling over the Internet. I believe that all gambling should be tightly regulated and has traditionally been done by the state regulatory responsibilities. It should continue to be so in my judgment, although it is appropriate for the federal government to have a role to assist the states in the total regulatory scheme. The federal government took such a role in 1961 with the Wire Communications Act as a way to assist in the fight against gambling by organized crime syndicates. The Department of Justice contends that it can prosecute Internet gambling businesses under that law, but clearly that law was not designed with Internet gambling in mind. While I appreciate the desire of my distinguished colleague, the distinguished gentleman from Virginia, Mr. Goodlatte, to update the ability of the department to address illegal gambling in today's context, I do not believe that H.R. 4777 is likely to be effective in doing so. Regulating anything over the Internet is problematic, even where desirable. Most law enforcement is local or jurisdictional based. The Internet has no jurisdiction, and as a result, I suspect that even if we were successful in closing down business sites physically located in the United States or in countries where we can get cooperation, because of the nature of the Internet and the ingenuity of people using it, the approach of H.R. 4777 will ultimately be ineffective. As we hear from our witness panel, this bill will create an enforcement nightmare for financial institutions because they would be required to look up and stop illegal gambling transactions. Identifying Internet gambling activities will be very difficult, if not impossible. While some companies may be able to identify some gaming transactions by codes used, such enforcement efforts can easily be thwarted. A business can have one code for payment purposes, but may be engaged in several activities, including Internet gambling. A casino, for example, may have a hotel or gambling. A foreign company may have a hotel, a casino, Internet gambling, an e-cash or electronics payment system, or any outside escrow agent can relocate to another country and therefore evade the enforcement mechanisms in the bill altogether. With some Internet gaming activities being legal, how would a financial institution distinguish between them and legal activities? Furthermore, we should not overestimate the cooperation we may get from other countries. According to Christensen Capital Advisors, Internet gambling websites brought in over $14 billion worldwide last year, which is up from $8 billion the year before. That number is expected to almost double to $24 billion by 2010. Presently, over 85 foreign governments allow some form of gambling online. That number is likely to grow as well. So what governments are likely to cooperate with us in prosecuting businesses they authorize to operate? And even if we're successful in getting cooperation from some countries, we would be simply increasing the profit opportunities for uncooperative countries, especially those with whom the United States does not have normal diplomatic relations. This bill does not prohibit Internet gambling. It prohibits running the Internet gambling operation. If we wanted to be effective in prosecuting illegal gambling over the Internet, we should prosecute the individual gamblers. A few sting operations, and the word would get around that if you gamble on the Internet, you will be caught. And so long as individuals can gamble over the Internet with impunity, a market will be provided for them, which a regulatory scheme in this bill will not stop. For example, Mr. Chairman, we prohibit the sales of illegal drugs. But we see that as long as there remains a demand for drugs, we have only limited success in the war on drugs. But if we took the approach in this bill in enforcing drug laws, we'd be prosecuting the seller, but not the buyer, and having even less effect than we have now. Since we're not talking about prohibiting gambling on the Internet, but simply prohibiting the operation of the illegal gambling site in jurisdictions that the FBI can get to, I believe that there are more effective regulatory approaches than the approach offered in H.R. 4777. However, the approaches must be developed, taking into account the technology and state policies with respect to gambling and Internet gambling practices and preferences. This is the effect of the bill authored by the full committee ranking member, Mr. Conyers, last year, H.R. 1223. It established a commission that would study the issue and make recommendations for a regulatory environment for Internet gambling that would be controlled by the individual states. States do tend to prohibit individuals from gambling, so Internet gambling can both be effective, and individualized to each state. Under the bill's regulatory scheme, if Nevada opted to allow Internet gambling within its borders, it could. If Utah prohibited individuals in that state from gambling over the Internet, it probably could, and that would be enforceable by the federal government and by the states that allow gambling, as well as the state of Utah, because in the fullness of time, a gambler could be required to provide a mailing address in order to get paid. If protection of the public is the goal of regulating Internet gambling, it is much more likely that those who choose to gamble over the Internet will do so under a licensed, regulated entity under the Conyers approach than under 4777. First, the consumer in a state where Internet gambling is legal will have confidence that if they win, they will be paid by the licensed, regulated operation. A consumer would have no similar confidence in fly-by-night offshore casino.com. As a result, from a licensed regulated internet gambling activity would drive business from the less reputable businesses, and they would essentially drive them out of business. Another significant result is that states that choose to authorize internet gambling can tax it. At a time when unauthorized gambling is flourishing, as I said, over $14 billion, with half of it originating in the United States, and when most states are cash-strapped, those states that have chosen to authorize regulated gambling could receive much-needed revenue from both the operators and the winners, while contributing to the control of the industry and protection of the gambling public. The overwhelming portion of those who play the numbers buy legal lottery tickets, which are regulated and taxed and actually pay lower odds compared to the illegal numbers operations. For the same reason, people will choose to gamble over who choose to gamble over the internet will patronize legal domestic websites, even if they have to pay taxes on the winnings. I believe we should regulate internet gambling, but we should do so effectively. We should not subject any single business sector to the sole or principal responsibility of doing the bulk of the enforcement work, whether it's the banking industry in this bill or the internet service industry as we tried in prior bills. There are ways to regulate internet gambling effectively, and a study commission to develop those ways is the best way to come up with them. Again, Mr. Chairman, I thank you for holding the hearing and look forward to the testimony.
I thank the distinguished gentleman from Virginia. We have been joined by the distinguished gentleman from Utah. While not a member of the Subcommittee on Crime, Terrorism, and Homeland Security, is a member of the full Judiciary Committee. And we have been joined as well by the distinguished gentleman from Michigan, the ranking member of the full committee. And Mr. Conyers, if you had a statement, I'll be glad to recognize you.
Thank you, Mr. Chairman, and members of the committee and our distinguished witnesses here. I think we have to come more specifically to grips about the issues raised, particularly by the gentleman from Virginia, Mr. Bobby Scott. Now, gambling is going on now. It's out of the barn, so to speak. But when you start doing something as futile as carve-outs in a ban on racing, you are on a slippery slope that's going to create more problems. Let me just make a few points, and I will probably not use my full 5 minutes. First, this measure claims to ban all forms of online gambling, yet specifically exempts betting on horse racing, pay-to-play fantasy sports, state-owned and operated lotteries. And so we're doing a picking and choosing of which gambling activities to sanction while disproving many others. And I'll be looking carefully to find out how we arrived at the decision of which gambling will be sanctioned and which won't. Number two, the bill's not likely to lead to any meaningful reduction in the current number of Americans that place bets online. Isn't that what the legislation ought to be about? Major financial service organizations already employ the bill's main enforcement mechanisms, and Americans can easily circumvent these prohibitions by using third-party payers or even foreign banks. Third, by eliminating a customer's access to the U.S. financial services industry, this bill may inadvertently make worse the most pressing dangers posed by the internet gambling industry. After all, credit cards play a vital role in determining an individual bettor's wage and tracking potential earnings and losses. By prohibiting their use, we effectively lose access to this key information. And finally, the bill proposes to establish a complex regulatory system for banks that is unworkable. It's all but impossible to comply with, and under the provisions of the bill, banks would be asked to determine whether a transaction occurring online was illegal or legal based upon the type of gambling activity involved and where the location of the transaction occurred and whether or not the transaction involved interstate commerce. Now, let's be real, my friends. If we really want to gain an effective control of the online gambling industry, we must regulate it. Establishing a partial ban, allowing some forms of gambling to continue without the benefit of adequate checks and balances only will make the current situation much worse. And I thank you, Chairman Coble, for allowing me to get these remarks in before our witnesses start their commentary.
I thank the distinguished gentleman from Michigan. Gentlemen, it's the practice of the subcommittee to swear in all witnesses appearing before it, so if you would please stand and raise your respective right hands. Each of you solemnly swear that testimony you're about to give this subcommittee shall be the truth, the whole truth, and nothing but the truth, so help you God. You may be seated. Let the record show that each of the witnesses answered in the affirmative. We have 4 distinguished witnesses with us today. Our first witness is the Honorable Bob Goodlatte, whom I have previously mentioned. Representative Goodlatte served the 6th Congressional District in the state of Virginia and was first elected to the Congress in 1992. He is currently co-chairman of the Congressional Internet Caucus. He was selected by Speaker Hastert to serve on the House Republican Cybersecurity Task Force. Prior to serving in Congress, Representative Goodlatte was a partner in the law firm of Bird, Condor, and Huffman, and he is an alumnus of the Washington Lee School of Law and Bates College in Virginia. And the statement about you, Mr. Goodlatte, is missing a conspicuous ingredient. You also serve as chairman of the House Agriculture Committee, unless there's been a change that's not known to me. Our second witness is Mr. Bruce Orr, Chief of the Organized Crime and Racketeering Section at the Justice Department. Previously, Mr. Orr served as Assistant U.S. Attorney for the Southern District of New York and Chief of the Violent Gangs Unit in that office. He also worked as an associate at Orick, Carrington, and Sutcliffe. Mr. Orr received his undergraduate and law degrees from Harvard. Our third witness is Mr. John Kent, professor at the University of Illinois School of Law. Previously, Professor Kent was employed in several state and federal government positions, and he also has served as a senior fellow at the London School of Economics. Professor Kent's research has resulted in over 30 articles in the areas of legalized gambling economic impacts. He has earned several graduate degrees in law and business, including an MBA, a JD, and a SJD. Our fourth witness is Mr. Sam, and sir, help me with your surname.
Vallandigham.
Mr. Vallandigham is Vice President and Chief Information Officer at the First State Bank, and headquartered where, Mr. Vallandigham?
Barboursville, West Virginia.
Thank you, sir. Prior to serving in his capacity, Mr. Vallandigham, try me one more time. Vallandigham. It's really not that difficult. Worked as Data Security Officer and Vice President of the Mortgage Department. He is also a member of the Independent Community Bankers of America, where he serves on Payments and Technology Committee. He was awarded his undergraduate degree from Florida State University and a graduate degree from Louisiana State University. Gentlemen, it's good to have each of you with us. Now, as I previously informed you, there will be a vote upcoming. We comply with the 5-minute rule here, as you all have previously been told. And when you see the amber light illuminate on the panel in front of you, that is your 1-minute warning. And then when the red light appears, that is the ice on which you are skating has become very thin. We will not unduly punish you, however, but at that point, if you could wrap up, we would be appreciative. Now, Mr. Goodlatte, I am told that you have another engagement at what time?
2:55, 3 o'clock, but I need to leave.
Well, so we'll start with you, and then you can depart, and if we're still going, you're welcome to come back. Mr. Goodlatte, you're recognized for 5 minutes.
Well, thank you, Mr. Chairman, for inviting me to testify before this subcommittee on this very important issue. Gambling on the Internet has become an extremely lucrative business. Numerous studies have charted the explosive growth of this industry, both by the increases in gambling websites available and via industry revenues. Internet gambling is now estimated to be a $12 billion industry, with approximately $6 billion coming from bettors based in the United States. It has been reported that there are as many as 2,300 gambling sites. Virtual betting parlors have attempted to avoid the application of United States law by locating themselves offshore and out of our jurisdictional reach. These offshore, fly-by-night Internet gambling operators are unlicensed, untaxed, and unregulated, and are sucking billions of dollars out of the United States. In addition, Internet gambling can serve as a vehicle for money laundering by organized crime syndicates and terrorists. Contrary to what many in the gambling community would lead you to believe, gambling is not a victimless activity. In fact, the negative consequences of online gambling can be more detrimental to the families and communities of addictive gamblers than if a bricks-and-mortar casino was built right next door. The anonymity of the Internet makes it much easier for minors to gamble online. Furthermore, online gambling can result in addiction, bankruptcy, divorce, crime, and moral decline, just as with traditional forms of gambling, the cost of which must ultimately be borne by society. In fact, I have been contacted by a constituent in my district whose son fell prey to an Internet gambling addiction. Faced with insurmountable debt from Internet gambling, he took his own life. Unfortunately, financial ruin and tragedy are not uncommon among online bettors. Traditionally, states have had the authority to permit or prohibit gambling within their borders. With the development of the Internet, however, state prohibitions and regulations governing gambling have become increasingly hard to enforce as electronic communications move freely across borders. Currently, federal law already prohibits interstate gambling over telephone wires. However, because the Internet does not always travel over telephone wires, these laws, which were written before the invention of the Internet, have become outdated. H.R. 4777, the Internet Gambling Prohibition Act, brings the current prohibition against wireline interstate gambling up to speed with the development of new technology. It also makes clear once and for all that the prohibition is not limited to sports-related bets and wagers. In addition, H.R. 4777 will add a new provision to the law that would prohibit a gambling business from accepting certain forms of non-cash payment, including credit cards and electronic transfers. This bill also provides an enforcement mechanism to address the situation where the gambling business is located offshore but accepts money from bank accounts in the United States. The bill also provides an additional tool to fight illegal gambling by giving federal, state, and local and tribal law enforcement new injunctive authority to prevent and restrain violations of the law. H.R. 4777 will return control to the states by protecting the rights of citizens in each state to decide through their state legislatures if they want to allow gambling within their borders. The regulation of intrastate gambling is within the jurisdiction of the states, so this bill leaves the regulation of wholly intrastate betting or wagering to the states with tight controls to ensure that such betting or wagering does not extend beyond their borders or to minors. While my legislation prohibits online interstate gambling, it does not overturn previous acts of Congress that address gambling. This is a strong anti-gambling bill that also protects the rights of states to determine what is and what is not prohibited within their borders. The opponents of this legislation have a lot to lose. Offshore online gambling websites are cash cows, and the greed that propels these companies leads them to solicit bettors in the U.S. despite the fact that the Department of Justice already believes this activity is illegal. The greed that motivates many of these offshore establishments has also motivated nefarious lobbyists such as Jack Abramoff to spread misinformation about previous attempts of the Congress to ban online betting. Internet gambling is a serious problem that must be stopped. The Internet Gambling Prohibition Act will help eliminate this harmful activity before it spreads further. I'm happy to answer any questions from members of the subcommittee and address some of the misrepresentation that is already occurring about this legislation when that opportunity arises. Thank you, Mr. Chairman.
And you ought to be congratulated. You beat the illumination of the red light, so the pressure is on you, Mr. Orr. Mr. Orr, good to have you with us.
Good afternoon, Mr. Chairman, Ranking Member Scott.
Pull that mic a little closer to you, Mr. Orr.
Afternoon, Mr. Chairman, Ranking Member Scott, honorable members of the subcommittee. Thank you for inviting me to testify today. I would like to commend Congressman Goodlatte, as well as Congressman Leach and Senator Kyle, for their efforts and long-standing commitment to provide law enforcement with additional tools to combat Internet gambling. Today, I'm happy to offer the views of the Department of Justice on H.R. 4777, the Internet Gambling Prohibition Act. I'd like to begin by noting that the government continues to investigate and prosecute illegal Internet gambling, with two recent examples. In January of this year, the U.S. Attorney's Office in St. Louis announced a $7.2 million settlement with the Sporting News to resolve claims that the Sporting News promoted illegal gambling from 2000 through 2003 by accepting fees for advertising illegal gambling. In April of last year, the U.S. Attorney's Office in the District of Massachusetts indicted 13 individuals on racketeering charges, which included allegations that the enterprise used an offshore gambling office and that customers placed bets over the Internet. The operator of the offshore gambling office has pled guilty. I'd like to say that the Department supports H.R. 4777 for several reasons. This legislation clarifies and strengthens our position that Section 1084 of Title 18 applies to both telephone and the Internet. This bill increases the penalty for a violation of Section 1084. It prohibits the acceptance of credit cards for Internet gambling. It provides a civil enforcement mechanism to enforce that prohibition, and it provides a method to cut off the transfer of funds to and from illegal Internet gambling businesses. The Department does have some concerns about certain provisions of H.R. 4777 that may weaken current law, that may allow some Internet gambling from the home. We view the existing statutes as prohibiting interstate bets or wagers, including bets or wagers on horse races. We have previously stated that we do not believe that the Interstate Horse Racing Act amended the existing criminal statutes. We are currently undertaking a civil investigation relating to a potential violation of law regarding this activity. We would have concerns about any change in the law that could be construed as permitting interstate wagering on horse races. We are also concerned about the definition of intrastate for the purpose of exempting certain Internet gambling transactions from the reach of 1084. The definition focuses on the location of the bettor and the betting facility, but ignores the routing of the Internet communication placing the bet. Under current law, the routing of the Internet communication is of great importance in determining whether the transmission is in interstate commerce. We are concerned that the proposed definition might weaken existing law. While we welcome the bill's provision of an injunctive remedy to restrain any person from paying or assisting in the payment of illegal Internet bets and wagers, we have concerns over the bill's limitation of the type of injunctive relief that may be obtained against an Internet service provider. We believe that the Federal Rule of Civil Procedure 65 should be the sole standard used by courts in considering whether to grant injunctive relief and what form that relief should take. We are concerned that H.R. 4777 permits gambling from the home, as this raises issues about gambling by minors and compulsive gambling. We have concerns about the requirement for the secure and effective customer verification and age verification set forth in the bill. Online gambling businesses cannot see the customer to do on-site age verification. Furthermore, the residence verification requirement set forth in the bill may not be sufficient to ensure that the bettor is in fact physically located in the same state as the gambling business when he makes his wager. The Department believes that Internet gambling should remain illegal. We are concerned about Internet gambling because of the potential for gambling by minors and compulsive gambling, the potential for fraud and money laundering, and the potential for involvement of organized crime. And to cite one example from this area, in January of 2005, the U.S. Attorney's Office in New York, Southern District of New York, indicted 17 defendants in an 88-count indictment for running an illegal gambling business that included both telephone and Internet wagers being placed with off-site betting facilities both in the United States and abroad. The principals in this scheme are alleged to be associates of the Gambino organized crime family of La Cosa Nostra. Thank you, Mr. Chairman.
Well, you too beat the red light. Pressure shifts to Mr. Kent.
I don't know if any...
You won't be unduly punished if the red light beats you, Mr. Kent.
Thank you, Mr. Chairman. I don't know of any academic who can do this in under 5 minutes, but I will give it a try. And I would also ask your kind permission for my written remarks to be included in their entirety, if you would, sir.
Without objection, it'll be done.
Thank you, Mr. Chairman, members of the committee, participants, and guests from the U.S. House of Representatives and the U.S. Senate. Thank you for your kind invitation to testify before the committee. Internet gambling destabilizes U.S. national security and the strategic economic base. This is a State Department issue, and I would like to raise your eyes a little bit beyond the Beltway and look at this from an international perspective. This was brought before the full House Committee on the Judiciary before in 1995 as an issue. Some of the problems with Internet gambling are, first, Internet gambling destabilizes U.S. and international economies. Secondly, it destabilizes and threatens the financial systems of the United States and the international economic system. Third, it destabilizes U.S. national security in the fight against terrorism. Fourth, it destabilizes military readiness. Fifth, it creates and facilitates new criminal activity. Sixth, Internet gambling fuels the fastest growing addiction among young people, gambling addiction. Seventh, Internet gambling creates enormous socioeconomic costs of $3 for every $1 in benefits. And finally, Internet gambling creates and facilitates government corruption in the United States and throughout the world. Internet gambling causes immediate harm and irreparable harm to the entire U.S. public. If you would reference to the first overhead, you will see that we have a headline here back in 1996 where 40 economists side against more gambling. Can you get 40 economists to agree on anything? Well, they agree on this. This is a slam dunk. Gambling is lose-lose for the public. It's $3 in cost for every $1 in benefits. For examples of sworn testimony by professors, academics documenting the immediate and irreparable harm caused by Internet gambling and the advertising of such activities, I have appended statements from 3 expert witnesses, including myself, sworn testimony from a California case, and I would direct you to that to those affidavits. Like drug addiction, the harms to the public, commonly referred to as the ABCs of legalized gambling socioeconomic impacts, caused by gambling activities via cyberspace and particularly via the Internet include new addicted gamblers, new bankruptcies, and new crime. If I could have the second overhead, please. The second overhead here is from the Michigan State Detroit College of Law Law Review. You can see there at the bottom, this is an older statement, talks about the teen population being addicted, and at the top in the upper right-hand corner, it talks about the crack cocaine of gambling. Now, this is the terminology of the sociologists. This is not my terminology, and you can see that Internet gambling is well known as the crack cocaine of creating new addicted gamblers. In the case of these concentrated and multiple electronic gambling devices, the accessibility and the new acceptability, that is the legalization to the public, dictates that new pathological, that is addicted gamblers, will double from approximately 1% of the public, increasing to 2%. Similarly, the new problem gamblers will double from approximately 2% to 4% of the public. When the category is specifically focused on teens and young adults, these rates are virtually doubled again to between 4% to 8% combined pathological, that is addicted, and problem gamblers. Children, teens, and young adults conditioned by the Nintendo phenomenon are already demonstrating double the pathological and problem gambling rates of the older adult population who matured without the video games and without the accessible, legalized gambling venues. Accordingly, the 1999 U.S. National Gambling Impact Study Commission recommended that there be no legalization of Internet gambling, actually called for a prohibition, and that the U.S. laws criminalizing gambling over the wires be strengthened and expanded to other jurisdictions. I'm sure you're familiar with this report. Gambling industry spokespersons have frequently referred to Internet gambling as the killer application of Internet technology because Internet gambling is crack cocaine to addicting new gamblers and because the feeder market is every living room, workstation, and school desk. What are the strategic solutions? It is to eliminate Internet gambling problems and other gambling problems by transforming those gambling facilities into educational and practical technology facilities, thereby stabilizing international financial institutions. Instead of legalizing a casino slot machine establishment at a failing racetrack in 1997, the Nebraska legislature bulldozed the racetrack, cut out all the gambling, and made it into an extension of the University of Nebraska and a high-tech office park, and they've just expanded that facility. On October 27, 2005, the Illinois House of Representatives voted 67 to 42 for the Senator Paul Simon Memorial Bill, one of the initial sponsors of the National Gambling Impact Study Commission. This bill was to recriminalize the Illinois casinos It passed the House. It's currently awaiting action in the Illinois Senate. Similarly, suggestions have been made to recriminalize gambling facilities in other states and transform the gambling facilities into educational and high-tech assets instead of giving the gambling industry tax breaks. On December 6, 2005, Pennsylvania Representative Paul Clymer, with 32 co-sponsors, introduced a bill to recriminalize the Pennsylvania casinos. Finally, in conclusion, the immediate strategic solution to eliminate or curtail many of the problems caused by gambling activities is a total ban on Internet gambling activities. Socioeconomic history demonstrates that the eventual solution to the U.S. and international gambling problems is to recriminalize gambling, wipe the slate clean, and transform gambling facilities into educational and practical technology facilities. Thank you, Mr. Chairman. Thank you, committee.
And I plead guilty for having been very naive. I should have known a professor could not have wrapped it up in the 5-minute time frame, but you didn't do too bad.
I did the best I could, Mr. Chairman.
And you didn't do
I'm
too
sorry.
bad at all. Good to have you with us, Mr. Bowden.
Well, he certainly took the pressure off me, so. Mr. Chairman, Ranking Member Scott, and members of the committee, my name is Sam Vallandingham. I'm Vice President of the 101-year-old First State Bank in Barbersville, West Virginia. I'm also a member of the Payments and Technology Committee for the Independent Community Bankers of America. Barbersville is a historical town of 3,183 people in the far western part of the state near Kentucky border. We have 50 employees, 2 branches, and $127 million in assets. I appreciate the opportunity to testify on the proposed use of checking and electronic payment systems to limit Internet gambling. I commend this committee and members for fighting against terrorism and money laundering. We urge you to recognize that small banks like mine have a substantial regulatory burden under the U.S. Patriot Act and Bank Secrecy Act to identify our customers while documenting and reporting suspicious transactions. ICBA believes that it is critical that our resources be focused where risks to national safety and financial soundness are greatest. Our concern is that the added burden of monitoring transactions for Internet gambling will drain resources currently engaged in anti-terrorism and anti-money laundering compliance and divert our attention from the daily operation of our bank. Ultimately, we question whether this legislation will actually reduce Internet gambling. Can Congress justify the time and expense required by community banks to comply with another layer of regulation? Additionally, regulatory burden is detrimental not only to the bank, but to the community that depends on us for economic stimulus, small business funding, job creation, and continued community revitalization. There are 2 bills pending before the House of Representatives that attempt to end Internet gambling through restriction of payments. H.R. 4777, sponsored by Representative Goodlatte of Virginia, and H.R. 4411, recently passed by Financial Services Committee. Although the bills have many similarities, there are some important differences. H.R. 4411 prohibits any person engaged in the gambling business from accepting credit, electronic funds transfer, checks, or other types of payment. The bill directs the Treasury Department, the Federal Reserve, and the Justice Department to work together to develop regulations requiring banks to identify and block restricted financial transactions. H.R. 4777 would update the law against interstate gaming to include Internet gambling and criminalize the acceptance of credit, electronic fund transfers, or other payments by anyone in the gambling business. The regulation and compliance burden created by these proposals is substantial. Their key enforcement mechanism would require banks to identify and block transactions between customers and Internet gaming companies. This will not work because the FAM fails to recognize the differences between the credit card systems and the check clearing and automated clearinghouse or ACH networks. Credit cards operate with an electronic system that assigns codes to identify the merchant and the type of transaction. Checks and ACH payments are routed from the originator of the payment, the merchant, to the receiver, the customer, using only bank routing and account numbers. The payee is not identified. Unlike credit cards, the check clearing and ACH networks cannot identify and block payments to Internet gambling companies, and they cannot reconfigure to function as a transaction monitoring service. This legislation, therefore, should exempt check and ACH transactions. Otherwise, it would require a massive overhaul of the check and ACH systems, create enormous regulatory burden, and give police-like powers to financial institutions to identify and block illegal transactions. The bill should give the Federal Reserve rule writing and regulatory oversight. The Federal Reserve is well acquainted with the payment system and knows the limitations of the check clearing and ACH networks. If the check and ACH transactions are not exempted, the resulting compliance costs to the banks and the payment system would be enormous. The CBO's analysis of H.R. 4411 determined that the cost to the private sector would be less than $128 million if it applies to credit card transactions only. CBO added, quote, If the regulations also include the requirement for banks to identify and block checks and other bank instruments, the direct costs to comply with the mandates could increase significantly, end quote. These costs will include the redesign and rebuilding of the payment system structure, increased labor and training costs to banks, redesign of checks and ACH formats, and education of the customer, as well as payment delays and significantly slowed payment systems. If the Congress wants to make certain transactions illegal, it should look for solutions that do not harm the nation's payment systems and do not saddle our banks with the burden of enforcement. The responsibility for identifying and blocking prohibited credit and debit transactions should lie with the credit and card networks, not the financial institutions. Only the credit and debit card networks have the ability to determine the origin of the transaction, and thus only the credit and debit card networks have adequate information to identify an illegal transaction. Neither my bank nor our nation's payment system can function as a transaction monitoring and blocking service as envisioned by this legislation. To the extent this legislation attempts to protect families and minor children, I assure the committee there are processes and procedures in place that permit a customer to rescind fraudulent ACH or check transactions. On behalf of my community bank and nearly 5,000 members of the Independent Community Bankers of America, I ask you to remember this as you consider the legislation and increased regulatory burden it would create for our industry. Thank you.
Thank you, Mr. Bellingham.
Mr. Chairman,
The gentleman from Utah.
I'm not a member of this subcommittee, as you know, but because of the peculiar effect that this has on my state, I would ask unanimous consent that I be allowed 5 minutes at some point in time to question the witnesses.
Without objection, I will do this caveat, Mr. Cannon. I will recognize you after I recognize the members of the subcommittee.
Thank you, Mr. Chairman.
Without objection, it's good to have you with us, Mr. Cannon. Before I start questioning, we thank each of you, and each of the witnesses alluded to gambling oftentimes. I'm a country music fan, and Merle Haggard, the popular country balladeer, recorded a song some recent years ago entitled The Kentucky Gambler. And the concluding words of the chorus were these: "But a gambler loses much more than he wins." And I think with rare exceptions, that's true. Now, some of these sports shows, Mr. Scott, I've seen lately gambling, some of those guys I think win much more than they lose. But I think generally the Haggard conclusion is correct. More lost than won. Mr. Goodlatte, the authority to authorize and regulate wagering has in large part been reserved to the states. What impact would your bill have on a state's ability to authorize and regulate wagering over the Internet, A, and B, if a state chose to permit wagering over the Internet, what steps would need to be taken?
Well, thank you, Mr. Chairman. It's an excellent question, and this bill is primarily designed to buttress the ability of the states to do what has traditionally always been the case in the United States. Gambling has been illegal in this country unless regulated by the states. The states, however, because of the very nature of the Internet, find it difficult to do that. And so by prohibiting and modernizing the Wire Act to cover the new types of transactions that were not contemplated in 1961 when the Wire Act was written 45 years ago, we are recognizing that new tools need to be provided to all levels of government, certainly to the Justice Department, but also to state and local governments to enforce the laws that the states have to regulate gambling in those states. Now, because we also recognize that the states have had the primary responsibility in this area, we tell the states in this legislation that they can regulate gambling on the Internet in their state if they meet two criteria, which, in my opinion, today cannot be met. Perhaps someday in the future technology may allow it, in which case then I think it would be up to each individual state to do that. But one,
hurry along, because we have the 5-minute rule again.
they have to make sure that the gambling is restricted to the confines of the state, and two, that minors do not participate. The technology does not exist to allow either of those, so Internet gambling under this legislation will be non-existent unless that technology changes.
I thank you, sir. Mr. Orr, in your prepared statement, you expressed concern over the possible weakening of federal law covering Internet wagering on horse racing. Are there other industries similarly situated to horse racing, and are they addressed in this bill?
Mr. Chairman, The department obviously continues to have the position that internet gambling should continue to be banned, and we would oppose, or we would have very serious concerns about any possible weakening of that ban. With respect to the existence of other industries, I'm not really qualified to speak. We would have the same concerns with respect to those other industries as we would to whether horse racing or any other industry is construed under the bill as getting some kind of permission.
Mr. Goodlatte, are any other industries so involved?
No, I want to make that very clear in response to some of the comments already made. There is no carve-out in this legislation for horse racing, for lotteries, or any other type of gambling. There is, however, as noted by Mr. Orr, a separate federal statute that addresses the issue related to gambling on horses. And some maintain that that previous legislation allows it. The Justice Department maintains that it does not. This legislation takes no position on that issue whatsoever. We do not attempt to repeal the statute, but we also do not interpret that statute in such a way to legalize gambling.
And that was enacted in the early 70s?
I believe that's correct.
Mr. Kent, in your opinion, what are the distinct concerns related to internet gambling versus gambling in person or other forms of gambling, A, and B, is the better way to cure the social ills associated with internet gambling to regulate the industry or to make it illegal?
Thank you, Mr. Chairman. First of all, let me clarify one thing. You introduced me as a law professor. I'm a professor of business and legal policy. We make more money.
I stand corrected.
Okay.
And congratulate you for that.
Thank you, Mr. Chairman. If we can get the overheads up there, my number 4 overhead might help visualize this. It's entitled Annual Social Costs for Pathological Gambler. Basically, we're talking about two phenomena here. One's called the acceptability factor, and the other's called the accessibility factor. If you have the acceptability factor, that means it's legalized, or as we're seeing common today, we see PR everywhere that says gamble, 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 and the younger generation is getting this message everywhere that it's okay to gamble on the internet. I see students walking around my campus with T-shirts advertising illegal poker sites, and they don't know it's illegal. So what we're talking about here, sociologists and academics reference as the acceptability factor, and that is the message that it's okay to gamble, and of course we've legalized certain types of gambling, and that further confuses it and sends the message. Then there's also the accessibility factor, and that is maximized by internet gambling. Accessibility, you don't have to fly out to Las Vegas anymore. You don't have to go down to the casino anymore. It's right there at every work desk, at every school desk, and in every living room. And so you're going to see an explosion in the numbers of pathological and problem gamblers. And the social costs are enormous, and these are the top studies in a table for the committee to review. And the social costs are at least $3 for every $1 in benefits.
Well, my red light illuminates. I don't have to recognize Mr. Scott, but Mr. Kind, do you think outright illegal or regulation? Which of the two?
I think outright illegal. And I testified
Very well.
before the National Gambling Impact Study Commission. They said prohibition. If you can't prohibit it, you can't regulate it.
And Mr. Banker, hopefully we'll have a second round. I'll get to you subsequently. The distinguished gentleman from Virginia, Mr. Scott.
Thank you, Mr. Chairman. I think Professor Kind has just indicated one of the problems I have, where you seek to kind of make it illegal, but it's not illegal to do it. It's just illegal to run the operation. If you want to prohibit the activity, it's my view that it ought to be illegal to gamble on the internet, and that would clearly be enforceable. Is that right, Professor Kind?
I think that I would like to leave the details of the practicality of this to the people drafting the legislation, and I do that with respect to your question, Representative Scott.
Well, Mr. Orr, if it were illegal to gamble over the internet, would you have any problem catching people gambling? I mean, if you busted a site, you can get their mailing list, and you can go after each and every one of them. Word would get around, and they would stop doing it.
Well, Congressman, as Congressman Goodlatte has already mentioned, approach of the federal government from the beginning of gambling legislation has been to support the states as the primary regulators or the ones with primary jurisdiction.
Well, with any kind of illegal activity, you catch both sides. You don't just go after the sellers; you also go after the buyers. Is that right?
Well, the government has, the department has traditionally focused on focusing on the large rings and trying to have the maximum impact per prosecution. We've gone after the most sophisticated and the largest operators, and we would continue that approach under this bill.
Is it illegal to gamble on the internet?
Not at the federal level.
Mr. Scott, if I might respond to that.
Yeah.
We've had this discussion before, and I certainly understand your point of view, but the fact of the matter is, as Mr. Orr indicates, we have always, at the federal level, focused on supporting the states and targeted the entities offering gambling services. But virtually every state has their own regulations regarding what individual bettors may or may not do. And so we are simply supporting their efforts in that regard. We don't think there needs to be a federal law in conjunction, in addition to the state laws that already target the individual bettors.
Okay, well, Mr. Orr, are you aware of anyone that's ever been recently busted for gambling on the internet?
I am not. At the federal level, as I've said, we don't have a prohibition, and I'm not qualified to talk about what the states have or who they have busted.
So you're qualified to what you've ever heard of?
I am not. I'm not familiar with any such case.
Okay. Have you, in your prosecutions, have you gotten anybody that lived and worked and didn't come within the jurisdiction of the United States?
Yes, we've prosecuted people who have conducted offshore gambling sites. Yes, we have.
And how did you? Where was the prosecution?
Prosecutions took place in the district courts here. One example is.
How did you get them here?
Or in one case, I think the defendant entered the United States and stood trial. Your question goes, I think, to the problems of international law enforcement, and I agree.
You're familiar with I forgot his name, selling pot seeds in Canada.
I'm aware of that case.
Okay, and they won't extradite him, so we haven't been able to do anything about it. Do we expect countries to extradite people running these sites to the United States so you can prosecute them? We have a number of ways of attempting to enforce our criminal laws against people outside the United States who violate our laws through extradition, through. Okay, these sites are running all over the internet. Who have you prosecuted that hadn't entered the United States?
Well, we need to get them here in the United States before we can prosecute them. There are many ways of achieving that. We certainly work very hard with our international partners to go after criminals who are violating U.S. law, even if they're located in other jurisdictions. It's not just a problem limited to internet gambling. It's related to all kinds of crimes. And certainly the department does not believe that the difficulties we face in prosecuting people outside the U.S. who commit crimes within the U.S. Should stop us from trying. And we will continue to work on this.
It's illegal now, is that right? To run a gambling operation, and anybody. How long would it take you to find a gambling site on the internet? A minute?
I think anybody can find an internet gambling site.
And it's not illegal to do it. To gamble on the internet.
There's no federal prohibition. That's up to the individual states.
Do you have any idea how much money is being made by the companies with the gambling done in the United States, both in the untaxed winnings and what we could get in taxes from the operator if they would submit to the jurisdiction and let us tax their operation?
Well, the tax question I can't really answer. The amount of business that's taking place on internet gambling sites has been cited in this hearing to be billions of dollars, and I believe that's correct.
Any other tax so far that you know of?
Not that I'm aware of.
Thank you, Mr. Chairman.
I thank you, Mr. Scott. The distinguished gentleman from Michigan and ranking member, Mr. Conyers.
Thank you, gentlemen, for your testimony. We seem to begin this discussion with a bit of a conundrum here, dealing with horse racing. The Department of Justice asserts, and before Mr. Orr testified today, that horse racing is not legal. But 4777 would make it legal. Mr. Goodlatte is shaking his head vigorously. No, I want to to be in the record. Mr. Orr, can you give us a little enlightenment on it? I've read your position, particularly at page 2. Where are we on horse racing in terms of gambling and its illegality?
Congressman, as I stated, the department's position is that interstate betting on horse races is illegal under 1084, and that was not modified by the Interstate Horse Racing Act. My understanding is from what Congressman Goodlatte has stated is that it is not his intention to change that. We certainly look forward to working with Congressman Goodlatte and the members of this committee to effectuate that intent.
Well, it's mentioned in the bill, though. Members claim that an amendment to the Commerce, Justice, State Appropriations Bill in 2000 legalized Internet gambling on horse races under the Interstate Horse Racing Act.
Mr. Conyers, if
Could
I be permitted.
Yeah, you can be permitted. What is your position on this? Is that true?
What the legislation does is it does not attempt to.
No. Wait. Let me pose the question. Did the 2000 year appropriations bill legalize Internet gambling on horse races under the Interstate Horse Racing Act?
I don't have an opinion on that particular piece of legislation. This legislation does nothing to change the status of that legislation. So if that legislation authorizes interstate horse racing, we don't change that. If the Justice Department's position is correct that that legislation has never allowed betting on horses via the Internet across state lines, we don't change that either. This legislation does not attempt in any way to overturn that statute, which was passed by the Congress and subsequently amended by the Congress, nor does it attempt to ratify the position taken by the horse racing industry on that. So there is no carve-out in this legislation for horse racing.
Well, let's look at the bill itself. Subsection F, nothing in this section shall be construed to prohibit an activity allowed under Public Law 9515, USC 3001.
That's correct, Mr. Conyers.
So, wait a minute. Nothing shall be construed to prohibit activity. So you're making it clear.
No. That says nothing shall be construed to prohibit an activity allowed
under. Yeah.
Right. But the Justice Department has already testified that they do not believe that that statute allows that activity. The horse racing industry would tell you to the contrary. We don't take a position what any particular activity may be allowed or not allowed under that act. We're making it very clear we're not overturning the act. We are also making it very clear that we do not take any position on what that act allows.
Let me read you from the Department of Justice statement that they submitted. The Department of Justice views the existing criminal statutes as prohibiting the interstate transmission of bets or wagers, including wagers on horse races. The Department is currently undertaking a civil investigation relating to a potential violation of law regarding this activity. We have previously stated that we do not believe that the Interstate Horse Racing Act amended the existing criminal statutes. H.R. 477, however, would change current law and amend it to permit the interstate transmission of bets and wagers on horse races. This proposal would weaken existing law. Is that essentially what you said here, Mr. Orr?
Congressman, that is the statement. That was, I think, I understand from Congressman Goodlatte that's not what he intended to do by this provision of the bill.
Well, wait a minute. This was after you wrote this. You talked to Goodlatte, and then you found out that this is not correct.
Right.
Or will you want to change it?
So our concern is certainly, we would be concerned if the law could be construed as changing current law, and obviously we look forward to working with Congressman Goodlatte and the members of the committee to make sure that
Well, wait a minute.
intended.
In other words, you think this should be, what you've given us is a change of, what you're telling us now is a change of what you said here.
That's correct.
And you didn't bother to explain it during your testimony. And I mean, this is a very unusual situation, Mr. Chairman. We've got the Department of Justice representative telling us that what he has submitted to the committee is not accurate because he's talked to Chairman Goodlatte and they've gotten it straightened out.
Well, we can remain concerned to the extent that the bill's provision could be construed as legalizing that activity, because we think, and that's a concern. So I can't say that our concern has been is completely addressed.
Well, I'm feeling better already, but this is a heck of a way to conduct. Here's a multi-billion-dollar subject matter before us, and I need you to please carefully resubmit to Chairman Coble and this committee where all of this comes out, because we can't have it both ways. I mean, either there's a carve-out here which is widely regarded to exist, or there isn't. And I thank the chairman for the additional
Thank the gentleman. I say to the distinguished gentleman from Utah, the distinguished gentlelady from Texas, Ms. Jackson Lee, has consented to let you precede her, so you now recognize Mr. Cannon for 5 minutes.
I thank the chairman and Ms. Jackson Lee. As I said earlier, Utah has a particular interest in this issue because it's one of the few states that actually has a total prohibition on, only one other state like Utah has a total prohibition on gambling. And while I am a clear, adamant opponent to gambling, one of the things I don't want to see is the opportunity for gambling in my state because we preempt state law. And so I've got to acknowledge I'm as confused as Mr. Conyers is about where we actually are in the State Department. So let me ask Mr. a relatively careful question, and then maybe we can elaborate. I read your testimony, and it lays out the issues pretty well, but just to be clear for the record, it's my understanding that the Department's position on Internet gambling bills, whether Leach, Kyle, or Goodlatte, is that those bills should not have exceptions or carve-outs, like the ones contained in Section 1084D and F. Isn't it correct that this is the same policy position the Department has articulated for at least the last 6 years?
Yes, that's correct.
And has that changed based upon your discussions with Mr. Goodlatte?
No. We continue to believe that interstate gambling on horse racing is illegal under 1084. My understanding is from what Congressman Goodlatte has said is that he does not intend to affect the current state of the law. Obviously, we want to continue to work with him on that, but that does not change the department's position that we believe this activity is and should remain illegal.
So if I have a kid in Utah who gets addicted to games or in computer games and Nintendo and the like, and he then gets addicted to gambling and he decides he likes horse racing, you're going to argue that whoever is providing that horse racing opportunity is violating the law, and the kid who's doing it is violating the law.
Certainly that the person providing that service, if they're doing it in an interstate fashion, is violating 1084. The kid would be violating the law under the laws of the state of Utah, as I understand it.
And you'd cooperate with the state of Utah in helping kids get a very clear understanding that they should not be gambling.
Absolutely.
Now, what happens when a clever lawyer argues that this bill ratifies because it doesn't take a clear position on precluding horse racing?
That's our concern, and that's why we continue to have a concern with that provision.
But it just seems to me you sort of shifted positions in talking with Mr. Goodlatte. You said it's not a carve-out, but this is a very difficult position because, of course, what I want is clarity going back to the people of Utah that you can't gamble in Utah. It's clear to me that that's going to be the attack or the response that or part of the response that anybody trying to argue before courts that horse racing is legal, they're going to focus on this and say everything was precluded except us. Therefore, we're obviously not precluded. And obviously, the bill itself says that we're not precluded. Doesn't that seriously undermine your position?
That's why we have concerns, and we want to. We understand Congressman Goodlatte's statement to be that he does not intend to legalize to change the current law, which we believe prohibits this kind of activity. To the extent that his bill could be construed to permit that, that's a big concern of ours, and we want to continue.
But it will be argued by proponents of horse racing that that's the meaning of this bill.
Our concern is that if the bill passes in its current form, it would, and that would raise the concerns I've stated.
Would the gentleman yield for just
Certainly.
a second? I just wanted to make sure that our friend from the Department of Justice understands the Reno Justice Department has the view that this kind of legislation has carve-outs. The Ashcroft Justice Department has the view that this bill has carve-outs. The Gonzales Justice Department has taken the same view, and now the Orr Justice Department agrees with all the previous.
Mr. Conyers, I believe the time belongs to. I think the time belongs to Mr. Cannon, Mr. Conyers.
Yes, he
did.
yielded.
Well, I said to. I'm sorry.
But I know that I only have a moment remaining, and so let me just say that I think the weight of all the at least the federal thinking on this issue is pretty consistent, and it is a cause for grave concern. I don't mean to be obstreperous with this bill. I don't want Utah to get bombarded with gambling that becomes legal and backdoor a system that is going to lead many kids to the kind of difficulty Mr. Kent has already talked about, which I think is an abomination. So, unfortunately, Mr. Goodlatte had to leave, and he announced earlier that he had to leave in time, so we're not going to be able to clarify some of these things. But this is the core concept, the core problem that I have with this issue. And either we resolve that for the sake of Utah, or I have to oppose the legislation strenuously. Thank you, Mr. Chairman. I yield back.
I thank the gentleman from Michigan.
Well, I just want unanimous consent to proceed for one additional minute.
Without objection.
Because it's very important that we understand that this carve-out didn't just get invented this afternoon. This has gone through several administrations. Mr. Orr, I think, has come around to what is more consistent with his written statement submitted, that there are likely carve-outs. Now, the good intentions of an author of legislation notwithstanding doesn't really amount to much in a Judiciary Committee hearing. I mean, we may, in good faith, intend a lot of things, but horse racing is a very lucrative business, and gambling is part of it. So we need to be very careful about this, and I'd ask the gentleman to give us his best thinking on this, and if there's anything he wants to submit to the chairman after this hearing, we'd be delighted to receive it.
Mr. Conyers, we will keep the record open for 7 days, and we'll have a second round. Now, the gentlelady, have you finished, Mr. Conyers?
Yes.
The gentlelady, and I apologize, Mr. Cannon, I didn't realize that Cannon had yielded to you. I apologize for that. Now, the gentlelady from Texas, Ms. Jackson Lee, is recognized for 5 minutes.
Did I lose? Mr. Chairman, let me, I appreciate the fact that we had a member and proponent of, I guess, the legislation, and it seems that he disappeared. Let me, first of all, raise the question of what, a very sort of broad question. You're trying to yield? Oh, I'd be happy to yield.
I just wanted to ask Mr. Orr if he knows that we have comments from the horse racing industry that confirm that they obtained a carve-out for their industry, that's their attitude on the subject. Are you familiar?
I'm not
with that
familiar
general?
with their comments, but well,
You wouldn't be
that-
surprised if that were the case.
that causes us concern. Yes,
Yes, sir.
Mr. Congressman.
Well, thank you very much. And I thank the gentlelady for yielding to me.
I'm delighted to you. Ms. Orr, I will follow up with you then. Mr. Goodlatte is not present, and forgive me for being detained at another meeting and engaged in another meeting and out of office here. Give me again the assessment that you have from the Department of Justice on the necessity of this legislation.
Be happy to do that, Ms. Congresswoman. The department supports this legislation. We believe that it, primarily because it clarifies and strengthens the position that the department has taken throughout, that Section 1084 applies both to telephone and to the Internet, gambling over, interstate gambling over telephone or interstate gambling over the Internet. And for that reason, as well as some of the additional tools that are provided in the bill, the department supports the bill. We do have several concerns about certain provisions of the bill, some of which we've been discussing here. They are outlined in my written testimony.
And my colleague just mentioned the carve-out for horse racing. Are you aware, or is the department aware of the various companies that offer online betting on horse racing already existing in, as I understand it?
I don't have a specific, I would have to get back to you on specific examples if that's what you're asking.
I am looking for that kind of explanation, if you would, because I guess where I'm going on this questioning, and I will include the other gentleman in just a moment, is both the necessity, but also the discriminatory fact or discriminatory aspects that may incur out of this particular legislation if we don't get it right. And so I'm sensing that we're not getting it right, and even with your support, I have great questions. I understand the Reno Justice Department, the Ashcroft Justice Department, and the Gonzales Justice Department all have taken the view that the bill has carve-outs that I think you are concerned about. Is that my understanding?
We have concerns about any carve-outs. We certainly believe that we would have any very serious concerns about any bill that would create an exception to 1084 and allow, for example, interstate gambling on horse races.
Okay. Well, with that in mind, since we have a state of confusion, I would be concerned about legislation that poses more confusion than solutions. Is it Mr. Kindit from the University of Illinois? Give me, just because I missed Mr. Goodlatte, your assessment on a bill that seems to have a discriminatory aspect. What are you trying to focus on in this legislation?
Well, I was asked to appear with regard to the socioeconomic impacts of gambling, and to that end, we just mentioned one thing that Representative Scott raised earlier, and that was about all the flow of income coming in. What I put up here in one of the overheads were the 8 leading studies, and no matter how much money you have coming in tax revenue, it doesn't cover the social costs. All 8 of those studies, and it's usually a 3-to-1 ratio of $3 in costs for every $1 in benefits.
Well,
but
let me, since you wanted to make your point, but let me make this point on your point, which is, have we challenged the industries across the board to actually invest in correcting whatever these social ills might bring about? Have we ever had a scenario where the industries have been taxed, if you will, to create a better atmosphere if, for example, some may have thought that the bill has defects in it?
Yeah,